Inventor should be somebody who contributed, had a meaningful contribution to some feature that's included in the claims. But that can be, what's meaningful. 6 or 8 guys are sitting here, 6 or 8 engineers are sitting around a table, and 5 or 6 of them are talking. There's one person at the whiteboard. Maybe she's going crazy, and 3 other guys throw out, hey, do this and that and the other thing, and then somebody else is just sort of sitting there nodding, or maybe they throw out one idea. It's these brainstorming sessions become very fluid, and it's very uncertain who invented what. So typically, if there's a group and they're sort of doing brainstorming, you may just say, look, you're all inventors. Where you can get into trouble is, and I have companies that say this, it's like, oh, well, he's left the company, he shouldn't be an inventor. And I say, well, that's we need that. That's actually not the legal standard. We don't like him anymore, or she went to a competitor is not a good reason to say they're not an inventor. Because the reason for this is you may cut them out, you may file your patent application, you may get your patent. 5 years down the line, your patent may be, your company's going great, you've got this patent, you file suit against somebody for infringing, and they find this person who left, and they say, well, she said, she was contributed to that, and you didn't list her as an inventor. So the patent, either you need to add her as an inventor, in which case every inventor to a patent, if they don't assign their rights, has the right, they're all joint and several owners of it, the entire patent. So she may be an inventor, and she has the right, we can go to her and get a license. Or the patent's just straight out invalid because you didn't name the inventorship right. So the safest thing to do is, if anyone who's in that circle where you say, they're probably an inventor, there's a form you file. All the inventors sign what's called an inventor declaration that basically says, I believe I'm an inventor of subject matter that's claimed in this patent application. So you've got them under oath saying, I believe I'm an inventor. And typically, if your company was set up right and you have the right employment policies, you've got some either formal, or you're either relying on, if you're in the state of California and they're a technical person, they're basically hired to invent. Their obligation is to assign to the company. You sometimes end up with these sort of independent contractor situations where I'm not an employee, so maybe I don't fall under that rule, but you better make sure that your contractor agreement has something in there about who owns the IP. So assuming you have all that, the safest thing to do is name anyone who has some reasonable proximity to that inventive nexus. Make sure they sign a declaration, get them to sign a formal assignment to the company. Because then, 5 years down the line, you try to have this argument about, I wasn't an inventor. You say, the first exhibit 1 during their deposition is, what's this? It's a declaration. Is that your signature? Yes. What does it say? It says, I believe I was an inventor. So are you lying then, or are you lying now, right? So it's slightly bigger tent is probably safer.